And now I remember to record, so let's do that again. Stephanie, how you doing today? Welcome.
Hi, Eric. I'm good. Thank you. How are you?
I'm doing quite well. Welcome to the Employer Handbook Lunchtime Happy Hour Zoom Chat Spectacular, HR, COVID-19, all that stuff. Why don't you tell everyone a little bit about yourself?
So my name is Stephanie Mensing, and I represent employees in Pennsylvania and New Jersey regarding discrimination, retaliation, and wage claims. I also review severance agreements and review employment contracts and draft employment contracts. Those are my primary practice areas.
All right. And if you were to kind of allocate your practice between the employee side and the employer side, what's the percentage there? Just so the folks have a sense.
Well, all of my litigation is 100% employee litigation, right? So representing employee plaintiffs. I have, a few smaller businesses that I provide counseling to in terms of sometimes it's just business operations or, contracts, whether not necessarily employment related, but I also, help them out with employee issues, handbooks, contracts.
All right. So, folks attending, remember, Stephanie she's a nice lady, but she's not your friend. Make all those questions very hypothetical. No, just kidding. She's great. It's a really unique. It's a unique opportunity that you folks have today, and I hope you take advantage of it with a bunch of hypothetical questions, because what we intend to explore today, among other things, is really like an insider view into kind of what is going on the other side of the V, so to speak, plaintiff versus defendant. What is the plaintiff looking at during COVID-19? What are the cases that are worthwhile to bring? What are employers doing right to mitigate the risk of Stephanie taking on some of these cases? And so, folks, I'll ask a bunch of questions because I want to hear the answers. But I hope you folks take advantage of that as well. There's a question. Eric, how are you losing weight when the rest of us are gaining? Oh, I'm staying static. I don't know about losing. trying to remain static. Watching. I use a couple apps on my phone to chart my calories, I guess. All right.
Do you have Eric, did you get a special camera that makes you look like you know how they say the camera adds like 10 pounds? Does your camera take 10 pounds away?
Yeah, so that's it. That's exactly it. All right. Folks, I'm going to talk let's talk a little bit about kind of a big issue that I'm sure most everyone on this Zoom chat is encountering, and that is severance agreements, right? Unfortunately, I prepared a number of them. The economy, we're not in a recession, we avoided that, but businesses are struggling. Certainly before PPP, a lot of people were getting laid off, furloughed. Stephanie, are you reviewing a lot of severance agreements for clients? And if so, what are some of the related legal issues that are arising when you're reviewing these severance agreements?
I've noticed I've had a lot more calls to review severance agreements since March. Some people really have just been caught up in all the layoffs, and there's really, I review it, ask, the questions that I always, would like to know. And unfortunately, a lot of people have just been caught up in it. I have seen a lot of, fairly generous severance agreements. So even if there is, a potential legal issue, you have to weigh like the pros and cons of pursuing it. And, I have seen in some of these calls, I have seen potential claims. COVID seems like it's a good excuse for certain employers to clean house, and maybe they want to get rid of some older workers, maybe some pregnant workers, or just workers who are sort of seen as problem employees over the years because they complain about things or they speak up about things in the workplace. So it's really about weighing whether there's an actual claim. Like I said, a lot of people have just been caught up in the layoffs, and there's literally like no claim at all.
So let's assume we have one of these nefarious employers. They're sitting there twisting their handlebar mustaches and trying to figure out how to get all the complaining riffraff out. You know, they want to get all their retaliation done in one shot, and they want to hide it amidst, you know, a number of legitimate layoffs, right? What are the challenges for an employee who has complained, or who is old, or who is suffering from a disability, who is laid off as part of a RIF, to present a viable discrimination claim?
It's, you know, it's difficult whenever you have a larger group of employees. You know, it's hard to prove that one person was selected for a discriminatory or retaliatory reason. You know, let's face it, COVID-19 is a legitimate non-discriminatory business reason. So you really have to look at the group or department that the person was in. You know, if there were any prior warning signs that the company wanted to try to get this person out, was, you know, if anybody else from the same group or department was laid off, the makeup of the group and department, you know, those who were and were not laid off. Another challenge is, you know, assuming that you can, you know, get past those issues. Another challenge is damages. And I've seen this mainly with people who were terminated right before COVID hit, because then a few weeks or months later, the employer ends up like laying everybody off. So the company would have, you know, a pretty good, a pretty good excuse to say, you know, we would have laid Eric off anyway. So the damages can be fairly limited as well.
So let me just talk a little bit to the audience about the mechanics of a reduction in force. And you know, hopefully folks on this call, on the Zoom chat, aren't the ones themselves who are drafting the severance agreements. You have outside counsel who's helping you with that. But a couple of things to think about. One is, when you're doing a reduction in force and it impacts individuals that are over the age of 40, the Age Discrimination and Employment Act has certain boxes that you have to check in order to protect a complete, total, general release. And one of those things is you have to give a knowing waiver. You can't. Another one is you can't have people waive future claims. I'm getting a little bit into the weeds, but the big one for employers, and just, you know, you'll know this when you see the agreement, is if you have a reduction in force, if it's part of an exit incentive program, or if it's part of a termination, that you have to provide these folks with 45 days in which to consider, up to 45 days in which to consider the agreement, and then 7 in which to revoke their signature. But part of that involves, you also have to include a matrix at the end of the severance or severance agreement, separation agreement, that lists by unit effectively. You define your decisional unit, and then you list by, can be by department, just some reasonable classification, the ages of the folks who were selected for the RIF and the ages of the folks who weren't selected for the RIF. So again, a lot of that's pretty wonky, but as just kind of a general baseline, if that's not attached, if that's not part of your severance agreement, and you're laying off a bunch of people and there are people who are over 40, you're going to have problems down the line. So that's a reason why you want to have outside counsel reviewing, blessing your severance agreements. You know, someone's asking right now, what do you do if you think the OWBPA chart, which is what we're just talking about, the Older Workers Benefit Protection Act chart of laid off people, is defective? What if the employer has not included everyone in the decisional unit, but only the people selected for the RIF? I'll ask that of Stephanie. What if you, Stephanie, if you're looking at that severance agreement, reviewing it for someone, and you see defects in that OWBPA chart, the last page,
Mm-hmm.
are you thinking it's time to maybe bring an age claim?
Possibly. I do see it happen. I've seen, you know, someone listed on a chart where my client's like, I don't even know who that is. But it's like somebody, and then the age is like 30 years younger than like my client and then the other person. So, you know, it's, you can definitely see, you know, mistakes in those. So, I mean, it really depends. It would depend on, you know, what my client's ages are, and, you know, some other factors. But
Someone,
sometimes those charts like do look discriminatory just by glancing at them. You know, I've seen, you know, some recently where the age of the person I was talking to was significantly higher than other people, you know, who weren't let go. But then whenever you get into the, you know, conversation, you realize, well, the other person was there like twice as long at the company. So then it sort of makes sense.
yeah, I mean, and that's what, and that's the purpose of the matrix. So you can see
Mm-hmm.
range. So by not listing everyone, you know, if your potential client comes to you and says there were a lot more people affected by this
Mm-hmm.
force, you only see 3 people listed here. There were really 20. Yeah, that's certainly going to raise some red flags for me.
Oh, for sure.
Yeah. Someone asked, Eric, isn't it 45 days for a reduction in force? I don't know what I said before, but yes, it is 45 days for a reduction in force that you would give to review the agreement. And if it's a single person layoff, and that person is over 40 years of age, you give them 21 days, up to 21 days in which to consider. You could give 45 if you wanted to. You only have to give up to 21. Stephanie and I were joking off air about the next question I'm going to ask her. I'm going to couch it in terms of the family feud. And I don't know how over everyone's head this is going to go. I'm going to stereotype it and say that the people with a little bit more gray hair are going to get this reference. Stephanie did not get this reference, but we managed to figure this out. So here it is. Stephanie, we're going to play the family feud. Top 5 answers are on the board. Here's the question. What employment laws are companies breaking most during COVID-19?
So just so everybody knows, I actually have never seen the show, so I had to Google to find out what it's about. Eric, our host for Family Feud, I will go with wage and hour issues.
Okay. And I think ding, 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 ding. That's going to be pretty high. I don't know if that's the #1 answer.
Oh, wait, they're supposed to go in order?
Well,
Or
you
just
I'm going to
5?
say that's #2. It's probably #2.
Okay. Sorry, I didn't get that from the Google search.
Let's pause there though on well, #1 answer gets control of the board.
Oh, okay. All right.
I think #1 answer is ADA.
Oh, okay. Well, that's actually on my list.
But now let's focus on wage and hour.
Uh-huh.
What are some of the wage and hour concerns that you think employers should have during COVID-19?
Yeah, I think one of the big concerns is that so many people are working from home. And I bet a lot of employers don't realize they're responsible for keeping accurate time records, which is a lot easier to do whenever everybody's in an office environment. But whenever you have people working from home and maybe they start working a little earlier and they work a little bit later because they're not commuting and it's just easier, or they feel like they have work to get done. So maintaining accurate time records is certainly important.
Yeah, there was the Department of Labor updated its wage and hour frequently asked questions recently. When I say wage and hour, that includes FMLA. So there was FLSA update, and there was an FMLA update too. But on the FLSA piece, one of their frequently asked questions, which they now on on July 20th, just got around to answering, was, you know, how do we pay our employees when they're working remotely? And I thought to myself, gosh, you know, if that's your question that you're still waiting on an answer to. But to your point, Stephanie, yeah, I mean, if record keeping is very important, not just for Fair Labor Standards Act purposes, but it remains important for FMLA purposes as well.
Mm-hmm.
I don't think the Department of Labor is doing many in-person audits right now, but they're going to when COVID-19 subsides, ends, hopefully, done. So record keeping is incredibly important. So I mentioned ADA. Are you fielding many ADA calls during COVID-19?
You know what I'm seeing? I'm seeing situations where there are people who, you know, their employers want them to come back to the office, but they have, you know, underlying health conditions. So they're like higher risk. And it's entirely possible for them to keep working remotely, but the employers want them to be in the office. So I think we'll probably, as offices start to reopen, see more of that, where somebody, maybe somebody has cancer, or they have, a serious, issue that makes them, more likely to have issues if they contract COVID. And if they make a request, a reasonable accommodation request to keep working from home, and they have they've been doing it for the last 5 or 6 months without any problems, then I think we'll see more issues right there with employers failing to accommodate.
How, if telecommuting and reasonable accommodation before was, here, right, as being reasonable, is it now like way up here is being more reasonable? Is it kind of close to where it was? What do you think?
I think it really depends on, how the employee, I guess, performed. But if the employee was maintaining productivity, the same level of productivity, and I think that it's going to be up here,
Oh,
because
wow.
you've established that it's reasonable for 5 months, 5 or 6 months during the pandemic. Why is it not reasonable for another 2 months?
Let's put it this way, in terms of, we'll couch it in terms that you and I can understand, and then to the extent that the audience is a little bit removed from this, we'll translate. So thinking about the life cycle of a case, the employer's biggest bite at the apple is summary judgment. You get an initial bite at the apple when you try and move to dismiss the complaint, and it usually doesn't work. So your last chance to avoid trial as the employer is you file what's called a motion for summary judgment. And that motion for summary judgment is your way of telling the court, look, all of the factual issues in this case are not in dispute. There are no material facts in dispute. So, Judge, we want you to apply the well-settled law to the facts of this case. I think that with telecommuting as a reasonable accommodation and determine what's reasonable, I wouldn't be surprised to see more judges kick that issue to the jury to decide what's reasonable in this situation. Unless, what do you think about employers who are kind of actively or thoughtfully updating their policies and procedures to take into account COVID and the reasonableness of telecommuting? That is, maybe they say, look, for the time being, in these particular positions, we'll consider, allowing you to telecommute is fine, but in these other positions, it creates an undue hardship because, what do you think?
I think it would depend on the articulated reason for the undue hardship. I mean, if it's not costing the employer any money, and they're not, it's not affecting the workers' productivity, it's not affecting customer or client relations, I think it's going to be, difficult to try to establish an undue hardship. I mean, and it really depends on probably the position, and whether the client or the employee has a client facing role, and what the person's role is and duties are. But I have friends who, they've obviously been working from home, and their companies have decided, hey, guess what? Your position is now permanently work from home. So I think a lot of people will just be sort of transition to that, or it will become, you can work from home a few days a week, in the office a few days a week.
Yeah. ADA, wage an hour, FMLA. You seeing? You getting calls?
Yeah, leave. Yeah, any leave issues for sure. I've seen those as well.
What about you getting any whistleblower calls?
You know what? I have actually not gotten any whistleblower calls, but I expect to in Philadelphia.
Yeah. So for folks that operate a business in Philadelphia, the city recently amended its local rules, local law to say that if you, as an employee, speak out, have a reasonable belief that an employer is engaging in creating an unsafe working environment due to COVID, and then you are later fired because of that, you've got yourself a retaliation claim against your local employer in Philadelphia. For folks here who either operate in New Jersey or practice law in New Jersey, it's very similar to the Conscientious Employee Protection Act in New Jersey, their whistleblower law. Philadelphia is limited to COVID-19 issues, but in Jersey, you could bring a COVID-19 whistleblower claim under SEPA. You could bring any whistleblower claim under SEPA. It is one of the, what's the word I'm looking for? Toothiest whistleblower laws in the country. It has teeth. It really, you can get a lot of damages for that if you've been retaliated against for blowing the whistle.
And Eric, I see that potentially coming up because, there's sort of like, especially in Philly, we reopen, but then, well, we don't reopen all the way. You still need to work from home when it's possible. So I kind of see that coming in where employers are, some are trying to, force people back to the office when maybe there's still a local shutdown order in place, or, no working in the office, and employees who object to that. So I do think that will be an issue that we start to see as things start to reopen. And then maybe if there's a second wave and we go back into lockdown mode and employers are still trying to get people to the office.
Before COVID-19, I assume it's the same now. I think we've talked in the past about how you might get a call from someone who was recently terminated by an employer, and they call you thinking that they have, we'll call it claim A. I was fired because my race, my religion, whatever. And from talking to the person, you kind of figure out that claim A isn't really the good claim here, if at all. It's claim B. Are you getting any of that now during COVID-19, that someone calls you thinking that they have this problem, but really their problem is that, and they've got a much bigger lawsuit, better lawsuit than they thought they did?
Yeah, I do. I see it. Well, this was before COVID too, but I see it a lot with unemployment claims where somebody calls about, they were denied unemployment, and then you run through, the list of questions and, finding out, what happened. And then you learn that there's a potential discrimination or a retaliation claim. A lot of calls, a lot of people, anytime somebody's fired, most people think it was a wrongful termination. So that term is sort of like very broad for lay people. And, you get calls a lot of times where somebody's like, oh, I was wrongfully terminated. You find out, no, they weren't, but they have a wage claim because they weren't paid their commissions or maybe bonuses, something like that. And a lot of times, like FMLA claims, somebody might think they have an FMLA claim, but then it kind of turns into, well, it's really an ADA claim because maybe their leave expired, they came back, but they still needed some accommodations, whether it was break or time off to go to a doctor, and the employer just like flat out denies it. So those are things that I, see a lot. When COVID first hit, I was getting a lot of calls from people who were just like, I got laid off, and of course they had no idea what was going on because everything was like really crazy because nobody really knew what was going on. And through some of those, I was able to help people realize that they could they were maybe owed some leave under Philly's sick leave law. And I can talk a little bit more about that if you think people are interested.
Yeah, sure. Let's talk a little bit about some of, because I think, this applies in other states and localities too. And I don't want folks on this Zoom to just focus solely on federal law, because oftentimes state and local law is a lot more employee generous than federal law. So yeah, Stephanie, talk a little bit about some of the local issues you're seeing with paid sick leave.
Well, what I actually found interesting is that a lot of the people I spoke to actually had no idea that Philly has a sick leave law. So that's a little scary because it's been in place since like August of 2015. So my guess is that there are employers in Philadelphia who don't know about it. Generally, covered employees accrue 1 hour of sick leave for every 40 hours worked, up to 40 hours in a year. And then if the employer has 10 or more employees, the leave has to be paid. Now, right whenever everything shut down in Philly, the city expanded the sick leave law to cover COVID related leave. So not just like the sick leave law, it's like if you're sick or a family member sick, but the expansion included any sort of like COVID related leave, which included mandatory business closures. So on like March 16th, whenever all these businesses shut down, a lot of them started laying people off without allowing them to take their accrued sick leave. And this caused like a huge problem in the restaurant industry. There were about like 400 or so employees who were laid off and they didn't get paid their sick leave. And after some, and actually I think it was really just the employers did not know that they had to pay it, because under the regular, just sick leave law, you don't pay out sick leave whenever somebody leaves. But the argument is that the employer should allow them to take their paid sick leave before being laid off. So, at the end of the day, the restaurant owners ended up paying the sick leave out. But that's, sort of, that's a local issue in Philly, but there are a lot of different, states or cities that have their own laws that people should be aware of.
Yeah. Let's assume that you've got a case that you initiated before all of this COVID stuff. Maybe you're at EEOC, maybe you're all the way in federal court at this point, and you're looking around and you're getting calls from your client saying, I lost my job, I need money. You're looking around and seeing employers are going out of business. Maybe you've sued a restaurant and you're not sure what the long-term viability of the defendant is. How much pressure is there now to settle cases that you brought on behalf of your clients?
I think, well, it sort of depends on some factors. So it definitely depends on who the employer is. Like you said, if it's a restaurant, the restaurant might not be around in a month or two. So there's certainly more pressure there. If it's a large employer and they're not going anywhere, there's less pressure. But then it also depends on the client and the client's needs. There are some people who, some clients, they need the money and they need it sooner rather than later. So, I always try to do what's in my client's best interest. And if it's in their best interest to get a quicker resolution, then that's what my goal is. I know, a lot of attorneys are feeling the pressure too, because nobody really seems to know when there'll be in-person civil jury trials, at least in like the Eastern District of Pennsylvania. There's some places that are, opening up, different states, but nobody who's trying cases here, really seems to know when the courts will be open. I had a case that was scheduled for trial first week in June. Spoiler alert, it got continued, it was postponed to a date TBD. And so the speculation is that it might not be tried until 2022. So what do you 2022? Well, I didn't actually get a date. It was just sort of speculation,
but that's actually right in range, because I had a conference with the court, federal court in Jersey, on Wednesday, and it's a fairly run-of-the-mill employment discrimination case that I'm defending, and the magistrate judge joked. I think he was joking. Maybe now you're talking, he was serious. He says, you guys aren't going to get to trial until 2023 or 2024. And this is a case that was just filed recently. I'm going to mute the person who just got on. There we go.
I've heard the same thing about New Jersey and federal courts in New Jersey, Eric, because New Jersey federal courts were already backed up pre-COVID because they had so many judicial vacancies. And so the last time I had a little status call with one of the magistrates in my cases, she was just like, you guys should really talk about settling this case, because we were backed up before and now we are like really backed up. So I can imagine, because the criminal cases are going to have to go first. There's, so much backlog. So it's a
I've got a
challenge.
2017 case in the District of New Jersey in federal court where I just filed for summary judgment 2 weeks ago.
Wow.
Yeah. Wow. Anyway, we talked about kind of the top claims that you're getting or you're seeing right now from the calls that are coming in. You mentioned unemployment being a big one, and I want to emphasize to the audience that now might not be the best time to double down on fighting someone's application for unemployment, because times are tougher than they've just about ever been in recent memory. And if there's anything that sticks in someone's craw, who's just lost their job, it's an employer who fights them on trying to get something to supplement their zero income. And that really can be a motivating factor to get that person to pick up the phone and call someone like Stephanie to say, hey, look, I want to get these sons of bitches. What are some of the red flags that you see when someone calls you? You pick up the phone and you start talking to someone, and you all of a sudden there's so many red flags popping up that you wish you'd never answered the phone in the first place. So, what is it you don't want to hear from someone when they call you?
So before I answer that, I just want to emphasize your point about unemployment. This has happened multiple times over the years where I've had people come to me because their employer fought unemployment. Sometimes it's somebody who was like a 30-year employee, and then they're going to fight unemployment. And that person never would have called me but for being denied unemployment. And so if the employer had just not challenged unemployment, they would not have ended up in a lawsuit. So, especially right now, it's not unless somebody gets really engaged in serious willful misconduct, I just don't think it's worth it.
Yeah, I'm with you. And I see it a lot as a mediator at the EEOC that, folks that are pro se, why are you here?
Yeah.
Employer fought me on unemployment. I wouldn't be here if my employer didn't fight me on unemployment. And the other thing about fighting unemployment is you're going to have a hearing before a referee, and there's going to be a transcript created of that hearing. And you as the employer, that's where the clock starts ticking for you, right? That's where the timeline really begins, because you're testifying as to why you terminated this person's employment. And if that person then goes to Stephanie and sues, right, and all of a sudden down the line, your reason or reasons for ending this person's employment have changed a little bit from your sworn testimony before the unemployment compensation referee, you've got problems as the employer. Shifting reasons, inconsistencies.
Hiding the decision maker.
Yeah.
I actually have that issue right now. And another problem with like unemployment is that a lot of times employers send these, like representatives who aren't attorneys, and they don't really know what's going on, and they don't understand there's potential claims. So I literally have a case right now, and I knew I was going to lose the unemployment hearing just because there was an allegation of willful misconduct. But I appealed it anyway so that I could get the transcript, because I squeezed out of the HR rep the person who made the decision. And I knew who made the decision, but they were trying to hide the person. And so now in the lawsuit, like the attorney who's representing them doesn't realize that this came out at the unemployment hearing because he wasn't there. And so they've stated somebody else made the decision. And the decision maker is key because it's a retaliation case. So, I mean, that's really, if you're challenging unemployment, you've got to have your ducks in a row and make sure that you're not shifting your reasons later on. But so, I didn't get back to your actual question.
Yeah. What are the red flags? The client calls and you just go,
It usually involves something like, I have a case you'd be very interested in. Like they're trying to like sell it to me, and words like, it's a slam dunk, there's no way we can lose, I think this case is worth at least, $5 million. Or you get like the opposite. You get like, I've called 10 other attorneys, but no one will take my case.
Oh, yes.
And then it's like, oh, I'm glad I'm number 11 on somebody's list. But those are definitely red flags. Sometimes it comes in the form of an unsolicited email that's like a 3-page single space paragraph that is very hard to read and understand. But those are definitely red flags. And also like someone who won't fill out my intake form. I try to get them an intake form. It's just a link that they get so that I don't waste time on a phone call. And if somebody can't be bothered to complete the intake form, it's a red flag that the person won't be responsive whenever I need information or documents to respond to discovery.
Oh, that actually jogged something for me. A little segue. Maybe it's a non sequitur altogether. But are you getting calls from people who have lost their jobs due to something you may have said or done on social media? Let's say about George Floyd or police or protests, anything like that?
I have not this year, but I've had it happen in the past where somebody said something stupid. And this was before, you had as much cancel culture, but there were still people around, and it was sort of a similar situation where somebody found it and tracked this person down and where the person worked. So I expect we're going to see a lot more than that, more of this in the future. People say some dumb stuff online.
16 police officers have sued the city of Philadelphia, claiming that more than 16 police officers lost their jobs due to stuff they posted on Facebook, and now 16 of them are suing the city of Philadelphia, bringing federal claims. Nothing that you could ever present in a private sector setting, but public sector, I suppose it is possible that you have your limited free speech rights could protect your employment.
That's right. Maybe we should just cancel Facebook and not have these problems anymore.
Oh.
But then I wouldn't see your employer handbook updates. So
yeah, and I wouldn't get to see in the neighborhood Cherry Hill post. I wouldn't get to see all the posts about what is this. There's like a picture of a bug outside someone's house. What kind of bug is this? I see these posts all day. It's enthralling. So I want to do actually before I get to, I have quick hits noted on our agenda, but I do want to ask you for the benefit of this audience, because we've been more like employee facing at this point, and I want to go employer facing a little bit. What are good employers doing well right now to mitigate the risk of a COVID-19 related lawsuit?
I think overall, just to really simplify it, it's treating their employees like people. For example, if people can continue to work from home, let them if they want. If people have, their employers who are working with people who have health issues or family care issues, they're working with their child care issues. Some employers are offering additional support for child care right now. It'll be interesting to see what happens, in the school year whether kids are going back or they're home 2 days a week and in school 2 days a week. So that will be interesting. Other things that employers are doing well is like making sure that employees don't feel like they're being treated differently if they have kids, running around in the background during Zoom meetings, or they're unable to go to the office, but other employees are. And even having like optional town hall type panels to discuss how discrimination against Asians or African Americans is happening, and why it's wrong and against what the company believes in. So there are a lot of employers that are doing stuff like that. Some of them are like cutting pay for higher level employees so they don't have to lay anyone off. So they're minimizing risk that way. And even when terminating people, you can still treat them like humans and be a good employer. Like I said before, I've seen some pretty generous severance packages, but employers can also look at things like if there's a non-compete, can they release the employee from the non-compete, or maybe make it less restrictive so that it still protects the company's real legitimate business interests, but allows the employee to actually go out and find a job. So, and then, we already mentioned, fighting unemployment. So, it's, like I said, it really is about, treating employees like people.
Yeah, you raised one point that I want to touch upon, and that is the return to school and hybrid teaching, or hybrid
Hmm.
schooling, I should say, for the kids. And the question that I've been getting from some is, if my kid goes 2 days on in school, 3 days remote learning, right, and the parents need to care for the children on those 3 days, is that considered intermittent FFCRA leave, or is that a block of leave? Um, Personally, and the DOL hasn't squarely addressed this yet, I think it's a block of leave, because you really have no choice as the parent. You're not choosing to keep the kids home. And as long as you're caring for the kid the entire day, I think it's just a 3-day block of leave that ends, if it's Wednesday, Thursday, Friday, it ends on Saturday, and then it starts up again the following Wednesday, as opposed to intermittent leave for 3 days, which employers do not have to provide. They don't have to provide intermittent FFCRA leave. They can, and the DOL encourages employers to do so and be flexible. But I think that's one of those situations where you really don't want to be too rigid, until the DOL allows you to. I mean,
Hmm.
at the end of the day, you're going to be able to get a tax credit for the leave, for the paid leave that you provide. So I think that's one of those situations where you do want to be extra flexible, because I don't know about across the country, but in the state of New Jersey, it seems like most, if not all, schools are doing this hybrid approach. So parents are going to need some help from employers.
That's last I heard, that's what they're considering in Philly. When that was just like a day or two ago. So it seems like it's, going to be something a lot of employers have to try to deal with and work with their employees.
You ready to answer some hypothetical questions that folks are asking for a friend?
Oh, sure, I'll try.
All right, I'll do my best as well. First question. I'm just scrolling down and doing it in order. All right. And if you have questions, use the chat feature and just pop them in the Zoom group chat, and we'll get to as many hypothetical questions as we can. If you start asking follow-up questions, I may start to skip you. Okay. Keep them short. Short, more likely to be read and answered. First question. Purely hypothetical. Can a private school cut teachers' salaries 50% while working remotely with students? I don't know what I don't know if these teachers are unionized or not, but in the private setting, I'm assuming not. I don't see why you couldn't cut salaries prospectively 50%. Issues may come up with, I don't know, Fair Labor Standards Act exemptions, I suppose, but as long as folks are getting paid more than whatever it is, 600 and change on a salary basis, and I assume the teachers could qualify into the professional exemption. Yeah, I don't see why you can't do it. You agree?
I agree.
Yep. Next question. What if lots of employees are furloughed for 6 months or reduced to part-time, but more than 50%? We're getting into a WARN question here. All done to perhaps evade WARN. We don't know what will happen in 6 months, but do you let your client sign a severance agreement, but scratch out the waiver of WARN rights? All right, so let's rephrase that question. Stephanie, are you concerned about a client who comes to you with a severance agreement giving up potential WARN rights in the future, if they're part of a reduction in force?
Yeah, I mean, I would definitely be concerned about it, and I might try to use that as leverage to negotiate, a higher severance amount.
Okay.
I mean, I expect the response I would get is, "Oh, we don't have to provide the WARN notice, and because we haven't, we've just furloughed people for 6 months." But okay, well then we'll just scratch out the waiver of WARN rights.
Yeah. And to get right, and for WARN to come into play, and I'm just focusing on the federal WARN right now, we're talking about a pretty large layoff. I mean, usually we're talking about 500 or more employees, although it could be less, or a plant closing that has 50. I mean, you're going to know if you're involved in a plant closing, presumably. But we're talking about, you know, larger companies with at least 100 employees laying off a large number of employees.
And Eric, sometimes I've seen they've taken employees from different sites so that you know, the warrant issues don't come into play because they're from different sites. So a handful from one site, a handful from another. So I don't really see that as an issue that's like coming up with people who are calling me, but I'm sure, I mean, it's possible.
How do you handle a situation where an employee hypothetically works in a restaurant and they fail to present documentation that they should isolate or quarantine due to a health condition? So someone says, you know, my doctor told me that I have to quarantine for 14 days because of concerns related to COVID. What if they're not producing documentation? My answer to that is they don't need to produce documentation. Really, all they need to do for purposes of giving the Ffcra is to provide their own name and the healthcare provider when they went to see them. I mean, that's pretty much it. Do you think that an employer should insist upon further documentation than that?
I don't think so. I mean, there are people who are, of course, you know, not being truthful, and they're telling employers that they have to quarantine because they've been exposed to somebody. But, you know, I don't think that a note's required.
Okay. And by the way, I mean, Stephanie and I were talking about this offline. I'm not going to belabor it here, but just to mention, you know, if an employee, for example, fakes having COVID-19, you know, comes to work one day and doesn't appear for work the next day saying, look, I contracted COVID-19 in the workplace, and they're lying about it, that's criminal, because what the employer inevitably is going to have to do is probably close down the office for a little while, send people home, clean it up. I mean, that's criminal. And the Department of Justice has actually brought charges against employees that have done that have knowingly lied about having COVID-19. So on the flip side, it's not as if the employer is without recourse if that happens.
It's sort of like the people who take FMLA to go to like Disney World.
That happens? And then they post about it on Facebook. See if we got rid of Facebook.
Yeah.
No, it would be more Instagram. Facebook owns Instagram, so.
Might be TikTok now. I don't know.
TikTok, right. We're a little older. There's got to be something better than TikTok now. I don't know. Anyway, what about mask orders? We haven't talked about masks yet. What about mask orders and remote work? Specifically, someone who refuses to return to work because they don't want to wear a mask. What do you do in that situation?
I think it depends on where you are. I mean, in Philly, everybody has to wear a mask. Well, supposedly everybody has to wear a mask. So I think in Philly, you say, listen, if you come to work, you have to wear a mask. I mean, unless there's a health reason why the person can't wear a mask.
And even then, it's a tough accommodation, right? I mean,
yeah.
Theoretically, you could put that person kind of in an isolated office off to the side, maybe. Theoretically, you could allow that person to telework, like if they literally have a disability that precludes them from wearing a mask. I think much of that is BS. I mean, I think it's just people kind of just saying, I don't want to wear a mask. But I suppose it's possible. The issue arises that, you know, there's a direct threat exemption to the Americans with Disabilities Act, that if someone creates a direct threat to themselves or others, you don't have to accommodate. They don't have coverage under the ADA. And I mean, it's not an employment situation, but for example, in my kid's school district, we've already gotten information from the district that every kid has to wear a mask. Even the little kids have to wear a mask. Kids who are in special education have to wear a mask. There are no exceptions. If you don't wear a mask, you're remote learning. So, you know, I think the mask is a pretty big deal for a lot of employers. Your question, if you're unable to work from home and have a condition such as cancer, how would you accommodate as the employer? So cancer makes them more susceptible to COVID-19. Can't work from home. How do you accommodate in that situation other than providing leave, basically, or FMLA? Yeah.
I mean, I guess it's possible if there's a private office where the person would not come in contact, but still, and you have to consider, does the person commute on mass transit? How many people does the person come in contact with? You know, I mean, it certainly warrants the, discussion about what's reasonable to try to find a solution.
Hey, Stephanie, I want to be mindful of the audience's time, but also yours as well. We have about 5 minutes left, and I see 27 questions left. I'm not going to get to all of them, but if we go into overtime a little bit, play some injury time here, to use the soccer football analogy. You okay with that?
Oh, I'm good.
All right, we'll go into stoppage time a little bit. Stephanie, are you seeing age as a factor in returning employees to the office? I mean, I know you talked about it earlier, hypothetically, that employers may tuck some older employees into a reduction in force, but what about bringing people back to the office? Are you seeing age motivate employers not to bring older people back?
I haven't really seen that. I mean, I've know people who are older who are concerned about going back, but I haven't seen employers using age as a way to screen, determine who's coming back and who's not. I've seen it obviously in figuring out who they're laying off. There's a lot of older workers, but I haven't seen it in terms of returning to the office.
Yeah, age being the new pregnancy there, right? Like, oh, we don't want you working in this difficult position for the safety of you and your unborn child.
Yeah.
The same motivation maybe from not bringing older stereotypes, not bringing older employees back. It's going to violate the Age Discrimination in Employment Act. Conversely, if someone who is older says, I don't want to come back because of my age, and that makes me more susceptible to COVID, you don't have to accommodate as the employer. Now, if that person then gets a doctor's note, different conversation. You're having an ADA interactive dialogue, but just age alone is not a basis for an employer to have to accommodate. Hypothetical case in which the employee with an immunocompromised system wants to come to work, although they have teleworking available. Oh, interesting. So maybe it's not that different from what we were just talking about 30 seconds ago. Someone who's immunocompromised wants to come to work, teleworking's available, bring them to work, right?
Yeah.
Their choice.
They might get sick, but it's their choice.
What about, I don't want to open up this can of worms. I have strong opinions about it, but I'll ask you, what do you think about having that person sign a waiver?
I've seen, I guess if you have everybody sign a waiver, maybe just acknowledging the risks of.
And I think that's the distinction right there.
Yeah.
You're not going to have people sign a waiver actually waiving rights against the company, because those exculpatory waivers don't play, especially not in Pennsylvania, not New Jersey, and not in most states. But an acknowledgement, some sort of affirmation of the risks of coming back, and that folks are going to take the necessary precautions themselves to control the spread of COVID-19, I have no problem with that. And I think that's actually a smart.
Yeah. I have seen employers try to get people to sign waivers saying they're waiving like workers' comp claims and the stuff that they can't possibly waive. So, but I think just acknowledging the risks and having people agree to wash their hands and stuff like that.
If a company that's experiencing a financial hardship due to reduced revenue from the pandemic decides to eliminate some positions, will they have to disclose their financials if one of the employees sues for wrongful termination claiming age discrimination?
I guess if it's their defense.
Yeah.
If they're saying our revenue went down, then I would want to see if the revenue actually went down.
Yep. If that's the hill in which you're going to plant your flag and defend, you're going to have to defend it. Plus, if there's a case involving a punitive damages claim, you're going to have to show your financials anyway.
That's right.
Yep. Question, on your ADA issue, when the employee's job generally requires a physical presence, like a teacher, the employee does have a disability, which puts them at higher risk, but all the teaching positions have already been filled. Oh, virtual teaching. Oh, what happened to the end of that question? I don't know. This is sound. I never got the. I don't know. The question kind of went away. Who asked that question? Dan Murphy. Ask your question again. It kind of got snipped there. I don't know what the actual question was. Looked like a good setup. Let's see. We have someone saying that state courts are starting a pilot program of jury trials in 3 counties in September. Part virtual, part live. It's good to know.
Oh, that's cool.
That. Here's someone saying that Massachusetts just implemented a mandatory 14-day quarantine for anyone returning from any state, except one of the New England states, New York, New Jersey, or Hawaii. Pennsylvania getting new level. Wow. Let's see. Does this constitute an order and trigger the Ffcra? I think it does. And I had a couple of blog posts about this where I went back and forth, and I want to thank some of my readers for pointing out my mistake. Because even a strong recommendation from the state that says you should quarantine for 14 days technically counts as a quarantine or isolation order. So a strongly worded suggestion does invoke, from the state, does invoke the Ffcra. At least that's my opinion. You disagree?
I agree.
Yeah, but I mean, again, I'm not giving legal advice.
Yeah.
I don't practice in Massachusetts. Don't talk to your Massachusetts employment lawyer. Let's see. Here are some people making comments. While companies don't have to accept certification for Ffcra, would it not make sense to align with other FMLA processes? So FMLA, this new paperwork just came out, optional paperwork for employee notice and certification and notice of rights and all that stuff. Does it make sense to have Ffcra documentation to support someone's request for leave? Yes, it does. I can answer this. Yes, it does. It makes sense to have an Ffcra policy. It makes sense to have an Ffcra leave request form, but it doesn't make sense to deny someone's request for leave just because they don't fill it out right away. The Department of Labor has made clear that if all it takes is an oral request. Really, what you need the paperwork for, what you want to have the paperwork for, is in case the IRS comes in and audits you when you're asking for those tax credits. So make sure you do have some paperwork. We had a very, very long, spirited discussion with my friend Kate Bischoff on one of these earlier Zoom chats. It's up on the Employer Handbook YouTube channel. We're recording this. This video will go up there as well. But we've discussed my personal need for documentation. Kate wasn't as bullish on that, but I don't want to speak for her. She's wrong. Anyway, moving on. How do you handle a person who claims the need to quarantine on multiple occasions? I've gotten that client call.
Let's hear your answer.
A week later, I think I've been exposed. A week later, I think I've been exposed. Never had COVID. Have you gotten anything like that from someone who they claim?
Not multiple occasions. I mean, I've seen it happen where somebody claims to have been exposed and then the employer found out later that no, the person wasn't exposed and made the whole thing up. But I haven't seen multiple claims of exposure. I want to know what these people are doing, and they're like, what are they doing when they get off work for their quarantine? You can't, not like you can go to Disney World or anywhere.
I wish I could share some of the stories that I've heard, but the common set of facts usually involves an employee who's around a family member, who was around another family member, who was around someone in the workplace, who was around another family member who might have COVID. And all of a sudden, you connect all the dots. The employee of ours says, "Oh, I've been exposed." So, Asking for a friend, someone says. Can an employer create a COVID-19 travel policy stating that for personal travel to a known hotspot, the employee will quarantine for 14 days? Remote work would be provided where possible. I don't have a problem with that.
Yeah, I don't think the employee would have a problem with that either. Getting back from a trip and then, working from home for 2 weeks.
Let me take it the next step. Let me ask you, Stephanie, what you think of my idea here. Let's go back to that Massachusetts question, right? So someone brought up that Massachusetts has a strongly suggested 14-day quarantine if you travel to certain other states. Pennsylvania has it, Jersey has it, New York has it. Let's assume as the employer, you don't want to give employees the ability to take a 1-week vacation to Florida, then come back and get a 2-week paid vacation on the company. I would suggest having a policy that says, if you travel to one of these banned states without permission, you are subject to discipline up to including termination of employment. Thoughts on that?
Wow. I guess if you're in an at-will state, you can prohibit people from going to Florida.
Yeah. And assuming we're not in a state like California or Colorado where there are conduct laws. I'm talking like a normal state. Sorry, California. We have our own California out here. It's called New Jersey.
That's right. Yeah, I guess it's probably not like getting back to treating your employees like humans. It's not the nicest thing to do. But if somebody called me and said, "Hey, I got fired because I went to Florida," I'd be like, "Well, sorry, there's nothing I can really do there."
That's right.
I would like to find out where I can work though, to go to Florida and then get 2 weeks paid vacation whenever I get back to Philly.
You give yourself a 2 weeks vacation if you want.
That's right.
I got to tell you though, in all seriousness, I'm looking into, I am not confident, knock wood. I hope I'm wrong about this, but I am not confident this hybrid learning thing is really going to hold up. And I think come like October, November, we're going to be full remote learning. I'm looking into like taking Bermuda or Barbados up on their offer. Have you ever gotten those ads? Like, come down here and work remotely. Like, why not?
Why not?
Wi-Fi. I don't have to be in court. Where am I going? My kids can they can do remote education, go out to the beach. That must be nice, right? I don't know.
I actually considered it, but it seems like I don't want to go somewhere unless I know that things are open, because what's the point in going somewhere if you can't go out and eat in restaurants or, and enjoy the local scene.
That's true. All right, let's do like 2 or 3 more questions, and we'll wrap this thing up. When an employee who has a child or children in school, and the children are sent home to quarantine due to positive cases in school, what kind of accommodations are going to be expected of employers? So kids go to school, children are sent home, not because they themselves have COVID, but because other kids or maybe a teacher has COVID. What should the employer do with the employee who has the kids who are now sent home from school that don't have COVID? What do you think? Did you follow that?
Sort of. It seems like it's
I can see.
Yeah.
I don't think it's really any different than what we were experiencing in the spring, right? Because school is closed at that point. Kids are home. I assume maybe there'll be some remote learning, or maybe not. Maybe it's just even more clear cut. The school is flat out closed. If parents need to be home to take care of those kids and they're not doing it intermittently and they have time left in the bank, they get their Ffcra leave. If it's a situation in which a parent is working remotely part of the day, but they have to take care of the kids part of the day, then I'd be flexible and get into some intermittent Ffcra. Next question. How are you handling employees who are claiming that they contracted or may have contracted at work? Do you do much workers' comp or any workers' comp? Because this is a workers' comp question.
Yeah, I don't do any workers' comp, but I'm aware that this could result in a workers' comp claim.
Yeah. Yeah. I mean, I don't do any workers' comp either. I know just enough to call a workers' comp lawyer. I know in some states there is a rebuttable presumption that if someone gets COVID-19, they got it from the workplace. In other states, not so much. It's going to be difficult to prove that you got it from the workplace, but I suppose, I mean, I'm guessing here. I didn't even say it at Holiday Inn Express last night. I feel confident about this, that if you do trace your COVID-19 to the workplace, that you're going to get workers' comp, pretty sure. Here's a question. Oh, let's see. Where am I looking here? If let's answer Marta's question. We'll do this as the last one. Are essential businesses able to not follow the quarantine recommendation after travel? So I think we're getting back to that Massachusetts, Pennsylvania, New Jersey thing. State strongly recommends that an employee who travels out of state, when they come back, 14-day quarantine. You're an essential business. Employee says, I just got back from Florida. State wants me to quarantine. And the employer says, yeah, great, but it's not mandatory. Get into work. We need you here. Can an employer insist on the employee coming into the workplace?
So this is sort of where we get back into the local laws, like Philly sick leave law. The expanded coverage covers, quarantine. So now it only covers up to the 40 hours if the employees accrued that amount. Also, I guess it would depend on if the essential business, it could be like a medical, or they could be exempt from the Ffcra. But if essential businesses are also like restaurant workers and other workers who are covered, so they would be able to take that leave.
My concern would be that you're maybe down the road fighting off a whistleblower claim. That you've got an employee who reasonably believes that they're being ordered to stay home. They tell the employer that. The employer says, no, you got to come into the workplace. The employee says, I'm not coming to the workplace because my employer, the state is forcing me to stay home. I'm required, or it's a strong recommendation. I'm going to abide by it. I don't want to get in any trouble with the state. Then they get fired and they turn around and bring a whistleblower claim. And all it takes is a reasonable belief in order to perfect that, what we call protected activity. I don't know if that would win or not. I don't know if it is a reasonable belief, but you're going to spend tens of thousands of dollars defending that claim.
I think it's certainly a reasonable belief if you're relying on like an actual government order.
Yeah.
So I would take that case.
Yeah. Is it right? So to answer your question, is it worth it to insist that employee come in? I mean, if he or she's the CEO, maybe. But if if he or she is widget maker number 7 on the widget line of widget makers 1 through 153, maybe not. I think that's all the time we have today. Folks, did you enjoy this? If so, let us know in the chat. We are recording this. I'm going to post it on YouTube later today. And I'll drop a link in Monday's blog post. I'll post links on LinkedIn. If you are not, speaking of LinkedIn, if you are not connected to either me or, more importantly, Stephanie, HR folks might need an employment lawyer down the line. You never know. You okay with people connecting with you on LinkedIn?
Oh, absolutely.
Yeah. And give me your website and all your credentials as well, so folks can look you up.
It's www.mensinglaw.com.
All right, I'm gonna pop that in the chat just so everyone sees it. And yeah, folks, thank you for coming out today. Hope everyone has a great weekend. I'll promise that I promise that there's at least one more of these coming up pretty soon. August 14th. I don't know what we're doing next week. I don't know what we're doing the week after, but August 14th, I think that's the Friday there. I'm going to be joined by several folks from the EEOC's Philadelphia District Office. And we're going to be talking about EEOC mediation, the EEOC's pilot program to expand mediation, not just focused on COVID-19, but, you know, a lot of folks have questions when they get an EEOC charge about, you know, what is this mediation option and how does it work? We're going to get all your questions answered. Other than that, thanks for coming out, and thank you, Stephanie. Had a good time.
Thank you. That's right. Thank you, everyone.
Thank you. Did I remember to hit record? Oh, I did. Awesome. I'm going to stop recording now. Bye, everyone.
Bye.